Good afternoon, and welcome to our Foreign and Comparative Law webinar on global perspectives of the regulation of IVF and related issues. This webinar addresses ethical and legal approaches to in vitro fertilization, IVF. IVF is a complex series of procedures that can lead to a pregnancy and is commonly used as a treatment for infertility and for the prevention of passing of genetic problems to a child. IVF makes it possible to create life through surrogacy as well as enabling human continuity after death. In addition to ethical challenges, creating life through assisted reproduction technologies raises a variety of questions regarding access, accrediting facilities, regulation of procedures to ensure safety, and funding. How long can embryos be preserved, and how can they be used? Should pre-implantation genetic testing be permitted? For what purpose? IVF procedures enable implantation of embryos in a gestational surrogate who does not have genetic connection to the intended parents. Countries around the world have different approaches to surrogacy, with some prohibiting it completely, and others conditioning authorization for surrogacy arrangements by fulfilling certain requirements. Legal questions may arise in cases of disagreement regarding the parental status of genetic parents versus that of the gestational surrogate. How should legal parenting be determined? How should legal parenting be determined in situations of mix-up embryos implantation? These questions are just some of the issues that arise in connection with the use of IVF. The webinar will provide information on the way countries around the world regulate IVF and related issues. If you have any questions, we ask that you submit them through the question and answer feature. Just click on the question and answer button at the bottom of your Zoom, input your question and hit send, and we will respond to them. I will be presenting the findings of a January 2025 report prepared by the staff of the Global Legal Research Directorate of the Law Library of Congress on the regulation of IVF in selected countries. The countries surveyed were selected based on their use of IVF, geographical considerations, and legal expertise of our staff at this time. They include Israel, the United Kingdom, and 6 European countries: France, Germany, Italy, Poland, Portugal, and Sweden. The report addresses, among other topics, access to IVF, regulation of IVF facilities, funding of IVF procedures, limits on the number of embryos created and transferred, storage, and pre-implantation genetic testing. Information on regulation of IVF in additional countries not covered in the report will be added as relevant. Additional information is based on research of relevant topics, including the Law Library of Congress website files of legal reports, and the Global Legal Monitor and our blog In Custodia Legis. During in vitro fertilization, mature eggs, ova, are collected from ovaries and fertilized by sperm in a lab. Then a procedure is done to place one or more of the fertilized eggs in a uterus. IVF can be done using a couple's own eggs and sperm, or it may involve ova, sperm, or embryos from a known or unknown donor. In some cases, a gestational carrier, a surrogate who has an embryo implanted in the uterus, might be used to carry the pregnancy. IVF is not new. The first animal experiments were published in the mid-1930s. While some commentators saw IVF as a promising development to help infertile couples, others were critical, saying that the scientists were playing God. Animal experiments also evoked eugenic questions that were the focus at that time, with concerns expressed in a 1936 New York Times article that, and I'm quoting, advocates of race betterment might urge such procedures for men and women of special aptitudes, physical, mental, or spiritual. In the press, there was a speculation about both surrogacy and a world where men were not needed for reproduction. In 1978, when the first child was born after IVF in the UK, the negative ethical comments of the 1930s were reiterated with more passion, particularly when attempts were made to introduce IVF in the United States. Among current concerns are whether there should be an upper maternal age limit for IVF, given the increased risk with advancing maternal age. This concern is particularly relevant if there is public financing of IVF, where cost effectiveness and prioritization of procedures are of particular importance. If donated eggs are used, some argue that limited availability of eggs may justify that young women with strictly medical infertility and a higher chance of successful pregnancy are prioritized over women with age-related infertility. Those objecting to age limits base their arguments on the right of children to be brought up under safe conditions and women's reproductive autonomy. Compared to upper age limits for the mother, there has been little discussion of age limits for the father. Men are, on average, older than women when they become parents and have somewhat shorter life expectancy than women. It could be argued, therefore, that the issue of being able to take responsibility for a child until adulthood applies equally, if not more, to men as to women. Another issue that reflects differences in attitudes is the appropriateness of use of IVF in singles and in same-sex couples, with arguments for and against involving fairness, non-discrimination, and reproductive autonomy and children's well-being. IVF procedures enable storage of embryos. When gametes, cells containing half of the genetic material necessary to form a complete organism, are collected and stored before cancer treatment, and the parent dies, should the remaining partner have a right to use them for IVF? Also, in case where a couple had embryos preserved and then separated, can one of them use the embryo for implantation against the will of the other? Do parents have a right to extract semen from their dead adult child to have a genetic grandchild through IVF? These are some of the moral and ethical questions that are associated with the extent to which IVF and related procedures may be used for human procreation. Other concerns focus on the use of certain techniques. While the use of preimplantation genetic testing, PGT, for early onset severe or lethal monogenetic diseases and structural chromosome rearrangements is relatively non-controversial, questions exist regarding the type of diseases that should be assessed. Could testing be based on non-disease characteristics with genetic influences, such as intelligence and beauty, what has been called pre-implantory genetic profiling? What about the use of pre-implantation tissue typing, PTT, to select embryos that could produce children suitable to become donors of stem cells or tissues for siblings who suffer from severe diseases? The merits of having a sibling can be, the merits of saving a sibling can be rationalized and commended. However, in other organ and tissue donation, treatment of a person solely for the purpose of becoming a donor is rejected. In pre-implantation tissue typing, questions on consent and the protection of children's autonomy become paramount. Another issue is preservation of ova against age-related fertility loss. The American Society for Reproductive Medicine Ethics Committee found that ova freezing in women attempting to safeguard their reproductive potential for the future was ethically permissible. Another somewhat controversial issue is whether a woman who is already having IVF may donate some of her eggs to other women, either as an entirely altruistic act or for a fee, or in return for the charges associated with the treatment. While this is accepted in some countries, other countries have taken a strict position against commercialization of organ or tissue donation, including donation of gametes, and only modest reimbursement of expenses is allowed. Another controversy related to IVF is surrogacy, especially when a pregnancy is initiated through insemination involving eggs from another woman than the surrogate mother. In full surrogacy, eggs and sperm may come from the intended parents or from external donors. Full surrogacy thus involves IVF with no genetic link to the surrogate mother, but with genetic links to two, one, or none of the intended parents. There is a serious debate about the morality of using another woman's womb to benefit couples or singles to bear a child. Another major concern is legal parentage. Who are the legal parents of a child born to a non-genetic mother or father from IVF treatment involving surrogacy? An even more challenging situation is what is the legal parentage of a child born to a non-genetic mother and spouse from misplacement of the fertilized ovum during an IVF treatment. All of these are difficult questions with which legislatures and courts around the world have been struggling. One of the most significant aspects of regulation of IVF is the extent to which access to treatment is provided. Who can access IVF? Access to IVF is commonly restricted by age, with different limits applied in each jurisdiction. French law allows for sperm to be collected from men aged 29 to 45, and for artificial insemination and use of gametes of germ tissue collection, retrieval or preservation, and embryo transfer up to the 45th birthday of a woman who is intended to bear the child, whether she is unmarried or part of a couple. For the partner who is not intended to bear the child, these procedures can be carried out up to their 60th birthday. In Israel, the maximum age for women undergoing IVF treatment is 45. In Italy, access to artificial reproductive technologies is restricted to persons 18 to 46 years old and a maximum of 40 years old regarding third-party donations. IVF treatments in Sweden are subject to various age restrictions. For example, in Region Stockholm, publicly funded IVF treatments are restricted to single women between the ages of 25 and 40, and to couples where the partner is between 25 and 56 years old. Private clinics may have slightly more generous age restrictions. For example, a clinic in Stockholm allows for 3 successive treatments to commence when a woman is not older than 41 years old. Other restrictions on access in some countries are based on gender or marital status. For example, in Italy and Poland, access is limited to heterosexual adult couples, married or cohabiting. France and Portugal limit IVF access to heterosexual couples and to same-sex female couples, regardless of marital status, but excludes singles and same-sex male couples. Under Swedish law, IVF treatments are available only to women who are part of a stable heterosexual or same-sex relationship or who are single and who are unable to conceive a child. Surrogacy, however, is prohibited in both Sweden and Germany. Interestingly, in the UK, limiting IVF treatment to heterosexual couples would constitute unlawful discrimination punishable under the Equality Act. Wide access to IVF treatment is provided under Israeli law, regardless of marital status or gender. Reproductive care in Israel is provided to spouses who do not have children in their current marriage, to same-sex male partners who do not have children, to childless women who wish to establish a single-parent family, and to childless men who wish to establish a single-parent family through surrogacy. Another important aspect of regulating IVF concerns the facilities where treatments are provided and the funding of procedures. Germany, Israel, Italy, Poland, Portugal, Sweden, and the UK require public and private facilities to be accredited by the state following a detailed approval process. Public funding of IVF treatments is available in many countries. In addition to state financing, Italy recognizes tax deductions for related expenses. Portugal authorizes the Ministry of Health to enter into agreements with authorized private centers to finance medically assisted procreation. In Germany, IVF treatments are partially covered by statutory health insurance for heterosexual married couples for up to 3 cycles, and the remaining deductible may be covered by a grant from the federal government. The scope of IVF procedures that are funded by states' budgets varied. For example, France's health insurance system covers a maximum of 6 insemination, 1 per cycle, and 4 in vitro fertilization attempts to achieve pregnancy. In Israel, new rule limits the number of extraction cycle to 6, depending on the age of the woman and the number of ova extracted in prior treatments. In addition to public funding, IVF treatments are covered by other sources. In the case of Sweden, where IVF treatments are funded by public as well as by private sources. In Israel, 67% of the total IVF activities conducted in 2021 were funded by state resources and 33% by health funds, in accordance with subscribers' individual insurance plans and copay. A similar percentage of IVF treatments funded outside of state funding was reported in the UK, where in 2017, approximately 60% of IVF treatments was privately funded, and the remainder was funded through the National Health Service, the UK taxpayer-funded healthcare provider. Regarding the scope of funding, there appears to be significant differences. Whereas in France, patients enjoy 100% cost reimbursement by the French health insurance system, reimbursement in Germany covers only 50% of the cost. In some countries, such as Italy, Portugal, and Poland, public funding covers IVF-related expenditures. In Israel, Sweden, and the UK, funding may be derived from both public and private resources. So we found different rules in the countries surveyed regarding creation and transfer of embryos. Well, there is no limit on the number of embryos created in France and Sweden. Germany limits the creation of embryos to 3 in 1 cycle. I think I covered that already. So let me go to the, I'll start with the UK limits are imposed in consideration of the prevention of multiple pregnancies. And in Italy, Germany, and Poland, the rules limit or discourage the creation of multiple excess embryos. Similar differences apply to embryo donations. While in Italy and Germany, the ability to donate embryos to another person or couple is prohibited or highly restricted, such donations are required in Poland after the storage time limit is reached. In France, Israel, Portugal, Sweden, and the UK, excess embryos must be discarded when the storage limit have been reached. In Germany, disposal of embryos is prohibited. I will move now to slide 10. The handling of embryos appears to raise both ethical and practical concerns. First, how long can or should embryos be stored? Who pays for the storage? The time frame for preservation of embryos varies among countries, with no limit existing in Germany and Italy, 3 years in Portugal, with the ability to extend for 3 more years, and 5 years in France and in Israel, with the ability to extend for an additional 5 years in Israel. The limit is 10 years in Sweden and 20 years in Poland. In the UK, it is up to 55 years for fertility treatment, with consent from providers of ova and sperm renewed every 10 years. While donation of embryos was found in our research to be permitted in most countries surveyed, subject to conditions prescribed by respective laws, the country's regulation of research in and disposal of embryos varies significantly, from full prohibition in Germany, Italy, and Poland, to experimentation in ova requiring written approval by the medical director of the hospital and compliance with the law and principles of the Helsinki Declaration in Israel. In Israel, Sweden, and the UK, experimentation in embryos is limited to 14 days of formation. UK rules also require that the donated embryo must be for a specific named project and stored for a period not exceeding 10 years for use in the named project within the UK. Another issue that has both ethical and practical ramification is PGT. In most countries we surveyed, PGT is used to prevent implantation of fetuses with genetic disease. France restricted PGT to exceptional cases. When the couple or an unmarried woman previously produced a child suffering from a genetic disease causing death in early childhood. Similarly, in Germany, PGT is allowed if there is a high risk of a severe hereditary disease or, with the woman's consent, to diagnose severe damage to an embryo that will most likely lead to stillbirth or to miscarriage. While sex selection of embryos is generally prohibited in Germany, sex selection of sperm cell is allowed if it is performed to prevent a child from getting severe sex-linked hereditary disease. Similarly, in the UK, sex selection of embryos may be done where there is a particular risk that a woman will give birth to a child who will have or develop a gender-related serious physical or mental disability, a gender-related serious illness, or any other gender-related serious medical condition. In Israel, approval may be granted by a designated national committee upon determination that there is what they call a great justification, considering a real risk of substantial harm to the mental health of the parents or of the children who will be born if the gender selection procedure of the newborn is not carried out, or when the applicants have at least 4 children in common of the same sex and do not have children of the opposite sex. Next slide. The introduction of IVF has made motherhood possible for women without uterus, with uterine abnormalities preventing pregnancies, with serious medical problems, or with other risks associated with the pregnancy, to achieve motherhood using an embryo created by themselves or a donor and transferred to the uterus of a gestational carrier. This technique has also made it possible for gay couples and single men to achieve fatherhood by having an embryo created with their sperm and donor oocytes. There are two types of surrogacy, as I mentioned before, traditional and gestational. Traditional surrogacy is the result of artificial insemination of the surrogate mother with the intended father's sperm, making her a genetic parent along with the intended father. Gestational surrogacy is defined as an arrangement in which an embryo from the intended parents or from a donated immature ovum or sperm is transferred to the surrogate uterus. In gestational surrogacy, a woman who carries the child has no connection to the child. Surrogacy may be commercial or altruistic, depending on whether the surrogate receives financial reward for her pregnancy. If a surrogate receives money for the surrogacy arrangement, it is considered commercial, and if she receives no compensation beyond reimbursement of her medical or other pregnancy-related expenses, along with the insurance coverage for her, it is referred to as altruistic. Next slide, slide 12. Surrogacy has raised many ethical concerns. The prime ethical concerns center on the potential for exploitation, commodification, or coercion when women are paid to be pregnant and deliver babies, especially in cases where there are large wealth and power differentials between intended parents and the surrogate. The counter-argument is that a woman has a right to enter a contract and to make decisions regarding her own body. Another ethical issue raised is in relation to the motherhood status of the women involved. Could there be a relationship between the genetic mother and the gestational mother? Is it possible to socially or legally accept multiple motherhoods? Should a child born via surrogacy have the right to know the identity of any of or all of the people involved in that child's conception and delivery? What is the status of the biological father and the mother's spouse? What about surrogacy and reproductive tourism? There are complex social, moral, ethical, and especially legal concerns involving cases where couples seek fertility services, and particularly surrogacy outside their country because of legal restrictions or financial costs. Next slide. Countries' approaches to surrogacy differ. Surrogacy is illegal in countries like France, Germany, and Sweden. Many countries permit surrogacy under conditions that reflect their ethical and moral considerations. For example, approval requires proof of altruistic motives in Argentina, Australia, Brazil, Canada, Greece, Guatemala, Mexico, the Netherlands, New Zealand, Portugal, Thailand, Vietnam, and the UK. Israeli law prohibits receipt or provision of compensation in money or equivalent value for the execution of a surrogacy agreement. A special surrogacy approval committee, composition of which is regulated by law, may approve, however, conditions in an agreement regarding monthly payments to the gestational mother to cover actual expenses incurring in execution of the agreement, including expenses for legal counsel and insurance premiums, as well as compensation for loss of time, suffering, and loss of income or temporary loss of earning capacity, or any other reasonable compensation. Unlike the countries I've mentioned, there are countries that do not prohibit commercial surrogacy. Such countries include Colombia, Georgia, Russia, Ukraine, and the US. The different approaches enable persons in countries where only altruistic surrogacy may be authorized to hire surrogates in countries where commercial surrogacy is permitted. Known as reproductive tourism, the situation poses some legal challenges in relation to the status of children born by surrogates outside of the beneficiaries' altruistic countries, their nationality, eligibility for birth certificates, etc. For example, France prohibits surrogacy. In 2014, the European Court of Human Rights found that France's refusal to register birth certificates of children born to French couples in the United States harmed the children's legal relationship with their intended parents and therefore violated the children's right to identity and private life, contrary to their best interest. Consequently, France was required to adapt its legal approach. The Cour de Cassation then determined that the mere existence of a surrogacy arrangement abroad no longer prevents the issuance of a foreign birth certificate, provided it is lawfully issued and reflects the established facts. The bioethics law of August 2nd, 2021, however, clarified that the recognition of parentage established abroad must be assessed considering French law. As a result, the transcription of a foreign birth certificate for a child born through surrogacy was limited to the biological parent. The intended parent had to follow an adoption procedure to establish a legal bond. This legislative framework remains more restrictive than the jurisprudence of the Cour de Cassation. For more on this, I recommend viewing our June webinar by my colleagues, foreign law specialist Stefania Alvarez and Luis Gilbert, titled Two Sides of the Same Coin, The Evolution of Surrogacy Law in France and Colombia, which is available on the Law Library of Congress website. Next slide. With regard to access to surrogacy, as I mentioned, when discussing access to IVF, countries' approaches differ, with some countries limiting access based on sex and marital status, and some considering the restriction of surrogacy to heterosexual couples discriminatory. Next. IVF procedures involve implantation of embryos in the biological mother or in a surrogate. There have been reported cases in several countries, including the United States, China, Israel, and the United Kingdom, where as a result of a mix-up, an embryo was implanted in the wrong woman. Who are the legal parents of a child born in such cases? This is an ethically and legally complex question. Should the legal mother be the woman who carried the pregnancy or the woman who is genetically related to the resulting child? Scholars have listed 4 approaches to legal parenthood in mix-up scenarios. The first is the gestation and the marital presumption. This approach bases greater emphasis and value on the gestational bond between a pregnant person and the child, acknowledging that pregnancy is a significant medically risky experience with both physical and emotional cost. The second option is based on genetic relatedness. The third one depends on the best interest of the child principle. And the fourth one recognizes multiple families. So far, courts have generally been hesitant to determine that a child has more than 2 legal parents. A recent Israeli case exemplifies the complexity of determining legal parentage in a mix-up situation. The case involved a child born from a mix-up of an embryo in the wrong woman during in vitro fertilization. The birth mother not only carried the pregnancy, but went through life-threatening medical procedure in the 36th week of her pregnancy in connection with a defect found in the fetus heart. The genetic parents' request to recognize them as the legal parents of the child was rejected. The Supreme Court determined that the child's birth mother and her partner were the child's legal parents, not the genetic parents, based on perceived preference given in Israeli law to the birth mother over the genetic parents in the absence of an agreement in a surrogacy arrangement. Analyzing the issue of determining parenthood in view of the Israeli case, scholars suggested that resolving embryo mix-up cases should be done proactively through the establishment of legislation and guidelines rather than relying on individual court decisions. Quote, such legislation and guidelines should guarantee the consistency of values throughout diverse reproductive contexts and mandate that fertility clinics and medical professionals provide individuals with comprehensive information regarding the potential risks associated with assisted reproductive treatments, end quote. A different issue is the determination of parentage of a child born using IVF technology after the death of a parent. Under Swedish law, a man married to a woman is presumed to be the father of that woman's child, born within 9 months of the man's death. In July this year, the Swedish Supreme Court ruled that a man can be assigned legal status of a father of a child even when the child is born more than 9 months after the man's death. In this case, a couple sought fertility treatment at a Russian clinic where a donated egg was fertilized using the husband's sperm. This occurred while the husband was alive, but he died unexpectedly from COVID-19 before the fertilized egg was implanted into the wife's body. Following his death, the widowed woman returned to Russia to have the fertilized egg implanted, relying on the prior consent her husband gave while he was alive. Then, 14 months after her husband's death, she gave birth to a child whose biological father was her dead husband, as proven in a DNA test. The widow sought to have his paternity established, but the husband's relatives opposed based on the birth taking place more than 9 months after the man's death. Rejecting an appeal by the relatives, the Supreme Court of Sweden determined that while the child could not automatically be presumed to have been fathered by the dead husband by relying on the paternity presumption, paternity could be established by the courts under the parental code. While paternity cannot be established by the courts when a single woman undergoes fertility treatment and in vitro fertilization without a partner, there is a special provision for establishing paternity when a spouse or cohabiting partner consents to the treatment. When it is likely that a man's sperm has been used to inseminate the mother, he will be considered as the father. Consequently, in that case, the dead husband was established as the father of the child, born 14 months after his death. It should be noted that the Swedish court did not set an upper time frame for how long after the husband's death assisted fertilization can take place for the husband to be considered the father. As a result, the ruling may affect inheritance provisions and execution of estates. Next. IVF makes it possible to create life after death if sperm or ovum was preserved. The use of assisted reproductive technology after the death of a parent raises ethical and legal questions. Is there a right to family life and to dignity of the human? Would the will of the deceased be taken into account? or will the family members who want to see continuity of the dead? Who may be allowed to request implantation? The deceased spouse? The deceased parents? What kind of evidence should be presented? If it was the will of the deceased to have a child, did he or she consider having a child after death? Did he consider having a child from a woman he has never met? In the case of sperm, if the deceased has not deposited sperm during his lifetime, may extraction of sperm after death be authorized? What about the interest of a child who will be born an orphan? How are succession rights to be determined in a case where the child was born after the death of the parent? Is surrogacy allowed and under what conditions? These are some of the challenges associated with posthumous procedures. Next. There are different approaches to posthumous assisted reproduction. France prohibits posthumous procreation. In a decision issued on November 12, 2019, the European Court of Human Rights denied the petition of a French mother to allow the transfer of her deceased son's sperm to a fertility clinic in Israel so that it may be used to conceive children. The son had expressed to her his wish to have children even in the event of his death and had deposited sperm at the French sperm bank. France's highest court has rejected the mother's argument that the prevention of the transfer of the sperm violated her son's right to decide how and when to become a parent, and her own right to become a grandparent. In its decision, the European Court of Human Rights stated that neither prohibition on post-mortem procreation nor the refusal to authorize the export of gametes on behalf of a deceased person are necessarily violation of the European Convention on Human Rights. Additionally, the court ruled that the deceased son's right to decide when and how to become a parent is non-transferable, and therefore the mother could not claim to be a victim of the convention violation on her son's behalf. Furthermore, even though the desire for genetic continuity was a respectable personal aspiration, the relevant article in the European Convention of Human Rights did not include the right to become a grandparent. A different approach is taken by another European country. Portugal allows post-mortem insemination and post-mortem embryo transfers using the sperm of a deceased husband or partner in cases where consent is clearly established. The donor must provide either written or recorded consent after being informed of the legal consequences regarding post-mortem insemination. In the absence of such documentation, the physician who oversees the process can provide a declaration confirming the existence of consent. Next. The wars in Ukraine and in Israel created an increased interest in the preservation and use of sperm of young victims and soldiers who died. Following the October 7, 2023 Hamas attack, the number of requests by Israeli families wishing to preserve the memory of their loved ones by bringing to the world children using their genetic material has significantly amplified. Because many of the soldiers were young and unmarried, most requests for extraction were made by parents. Military authorities instituted a new protocol. When notifying the family of a soldier death, IDF immediately offers the option to have doctors retrieve and preserve the sperm of the deceased, a technology that was not used frequently before the war. The use of sperm of a deceased person, however, has not been regulated by Israeli legislation. Requests from spouses and family members for approval of posthumous use of sperm have previously been decided based on an examination of each case on its own merits and on the guidelines established by the Supreme Court rulings and by the government. In a 2016 decision, the Israel Supreme Court authorized the use of a deceased sperm based on proof of the deceased will, not the will of his relatives, in relation to the possibility of having children from his sperm after his death. The court held that in cases where the deceased did not have a spouse, intent could be proven only through weighty indications that the deceased desired continuity after his death. According to Israeli case law, when determining whether to approve posthumous conception using sperm from the deceased, the focus is on the will of the deceased. When the deceased was married or living with a permanent partner and did not leave behind children, there is a rebuttable presumption that the deceased wished to have children with his partner. When the deceased was not married and did not live with a permanent partner, to allow parents to use his sperm to impregnate an unrelated woman, it must be established that the deceased wished for his sperm to be used after his death to bring a child into the world with a woman he did not know. In July of this year, an Israeli family court authorized the use of sperm taken from the body of a 19-year-old soldier shortly after his death for the purpose of fertilizing the eggs of a woman to be chosen by his mother. The court determined that the fallen soldier's presumed desire for the continuity of his sperm, even after his death, and even by the surrogate, was proven based on a testimony by his childhood friends. The friend testified that the issue of freezing sperm came up in an explicit conversation between them on the eve of their entry into the fighting in Gaza, a battle from which the son never returned. Next. The ongoing war in Ukraine has similarly generated unprecedented ethical, legal, and social dilemmas, significantly influencing national policy regarding reproductive rights and the use of assisted reproductive technologies. One of the most pressing and novel questions concerned the post-mortem use of sperm, particularly whether and how sperm can be preserved and used after the death of a serviceman for reproductive purposes. This issue intersects with deeply rooted cultural values, technical questions of medical practice, as well as fundamental rights under Ukrainian law. On December 21, 2023, President of Ukraine, Vladimir Zelensky, signed legislation to ensure the rights of soldiers to biological post-traumatic parenthood or motherhood. The law stipulates that during a period of marital law or martial law or emergency, as defined, military personnel will have the right to free services of taking, preserving, and storing reproductive cells obtained from the military in case of loss of reproductive functions due to injury, trauma, or contusion. Under this law, however, in the event of the death of a serviceman, the storage will be terminated and the reproductive cells disposed, eliminating the possibility of using the biological material after death. This caused public outrage, as many wives or husbands of military personnel noted that such restrictions deprive them of the opportunity to realize the will of the deceased to become a father or mother. In response, Ukraine's government passed legislation in early 2024 to provide free cryopreservation of reproductive cells for military personnel and other performing state defense duties. A legislative package adopted for 2024 and 5 guarantees, pending each donor's documented notarized consent, the right of the surviving partners to use their cells in reproduction after death. The amendments further prohibited blanket destruction of genetic material post-mortem, and they have also prompted the reform of inheritance and family laws to provide for recognition and rights of posthumously conceived children. Legislation passed in February 2024 provides for free storage of gametes for 3 years from the death of the donor that can be extended at the expense of a person specified in the will. On January 24, 2025, the Cabinet of Ministers of Ukraine approved a resolution that allowed the actual launch of a cryopreservation program. In 2025, the state budget of Ukraine allocated funds for implementing the program and covering the cost of the cryopreservation. Parallel to the adoption of these measures on post-mortem cell use, in August 2025, the government reportedly advanced a comprehensive draft on assisted reproductive technologies that included legal regulation of surrogacy. Next. We have now arrived at the end of this webinar. I will be happy to answer questions, time permitting. So let me see. I believe I should be getting an email with the questions. Barbara? Okay.
Hi, would you like me to read them out?
I think I maybe, yes. Let me take this one. You talked about criteria for access to IVF treatments. Is there a criterion for mental or physical fitness of the parties involved, particularly those of the expected mother? Well, the medical criteria in some countries often centers on age requirements and on the likelihood of success attested by a physician. This is the case, for example, in Germany, where such requirements, in addition to others, exist, but do not directly fall into the category of mental or physical fitness. The likelihood of success of a pregnancy is similarly taken into consideration in Israel. In principle, women with medical problems are not automatically excluded from IVF treatment. However, the medical team may recommend refraining from treatment if it poses an especially high risk to the mother or to the embryo. The decision, in many cases, is based on individual circumstances and on medical, ethical, and legal considerations. For example, severe heart problems, cancer, or other medical situations that in which pregnancy constitutes a clear and immediate danger to the health of the mother. So with regard to intellectual and self-regulation challenges, such issues may affect the ability of a patient to understand the procedure and the implication of the procedure. So in principle, in Israel, the decision by the medical team will be based on guidance by the Ministry of Health, but also on balancing the right of the woman to attain motherhood and the principles of medical safety and the welfare of future born child. In Sweden, however, they do have a specific attention to this issue. The law on genetic integrity requires that the responsible physician determine the medical, psychological, and social conditions of the parents, and the insemination may only be carried out if it can be assumed that the resulting child will grow up in beneficial conditions. This typically may mean that depressed mothers or people with who are with unstable financial situations cannot receive IVF treatment. Let me see. I have some comments here. Well, I have a question here which is relevant to the discussion of IVF. When does life begin? Is it regulated by the jurisdiction covered by the report, and how? This is obviously an important question in the context of IVF and the use of assisted reproductive technologies, particularly relevant in relation to the creation and disposal of embryos. What constitutes life is, as we know, a controversial issue regarding abortion. Religious perspective on life vary among different religious denominations. Our staff we have not examined the laws of different countries for a specific definition of life, but we did look at the regulation of abortion and reproductive rights, and there are several reports and global legal research articles authored by specialists of the Law Library Directorate of Legal Research that address countries' different policies and regulation of abortion. These resources you can access from the Law Library of Congress website, and I believe that we can send you a link to the website if needed. I have another here. Okay, this one is specifically regarding Germany. Germany's rule limiting the creation of embryos to 3 per cycle was enacted a long time ago, and it is very outdated. It leads to high numbers of selective reproduction, and now science shows that freezing embryos leads to greater success. Are there efforts in Germany to reform this law? I would suggest that this question would be forwarded to us through the Ask the Librarian feature. I believe you see a link to it. We do have a German expert on staff. Maybe this could be answered. There are I don't see any additional questions. If you have any follow-up questions that you would like to direct to us, please use the feature that is available on the slide. And I hope that we answered the questions that you had. We welcome any follow-up questions. Thank you very much. Have a nice afternoon.